We're Armstrong, your real estate agent and advocate. So glad we can be here. All right. Don't forget to like, share, and subscribe. But we're getting ready to go to court, Judge Simpson's court. We're still in his landlord tenant docket. So thankfully, we have some great events going on. So to keep us entertained, informed, and educated on the matter. All right. So come on in. We're ready for court, Judge Simpson. We are ready for court. Are we ready? Because I don't know if I can hear. Oh, there we are. We are ready for court. Let's go.
The 14th District Court is now back in session. All those having business before the
I forget to remind you, we keep things loud. So unplug, protect your ears, or turn down your volume if that's necessary.
court drawn near, the Honorable Judge J. Cedric Simpson presiding.
And good afternoon. Court does call the case of Arbor Meadows versus Hussein.
I'm here, Your Honor.
Everybody
All
moves
right.
around.
And sir, I have received a dismissal.
Oh, wonderful.
You have any objection to that?
Oh, of
No.
course not.
Okay, I didn't think so. All right, you have a great weekend, sir.
You too, sir. Thank you very much.
Court calls the case of Affinity Investment and Technology versus Willie Cater.
Good afternoon, Your Honor. Ron Rourke for the plaintiff.
Good afternoon, Your Honor. Willie Cater.
Okay, and where are we on this, gentlemen?
Mr. Cater still owes $12,600 in rent, so we're asking for judgment.
How much?
I thought
What was the amount, sir?
$12,600 in rent, back rent, April through September.
All right. Mr. Cater, what do you have to say to that?
thought me and Mr. Warwick had an understanding because my first payment was due today. I'm at work right now, but I guess we didn't. Maybe last week, I guess it was fine. So I guess, did you change your mind, Mr. Warwick, or what happened?
We never agreed on it. However, Your Honor, I am willing to enter into that understanding. If I get a judgment of possession in the judgment, I'll simply put that as long as he makes his payments, we will not seek a order of eviction.
Okay.
What are the terms of the payments, though?
Mr. Cater suggested $1,200 payments on a weekly basis beginning today. And he'll make $1,200 payments through September 29th, a $1,400 payment on October the 6th, and then $1,200 on 10/13, $1,000 on 10/20, $1,300 on 10/27, $1,800 on 11/3, and $1,100 on 11/10. That's $12,600. He'll still be 3 months behind, but as long as he makes those payments, I will not seek a order of eviction.
Mr. Cater, is that what
Yes,
you want
Your
to do?
Yes, Your Honor, I do want to do that, but also, Your Honor, I would like to also make it a thing that Mr. Warwick make it to my landlord that the things that have been not fixed for several months now needed to look ASAP because the flooding in my basement every time it rained, it doesn't stop.
So we're going beyond just payment as an issue. There's habitability as an issue. So we can't enter a judgment with these
None of that
issues.
doesn't stop, and that's about it. The things that we've talked about to get
Has to
fixed,
be
all I want you to do, Your Honor, is
fixed.
to get fixed.
Yeah, gotta be
I'd be
fixed.
glad to talk to the landlord about that, Your Honor. I'm not sure exactly what's going on with that, but I'll talk to the landlord about it, make sure the place is continuing
Okay,
to have.
I'll go.
So,
Yeah.
well, my problem is I don't mind entering into this, or this agreement, the payment agreement. However, the problem is going to be if he's claiming repairs
Mhm.
and I don't know what those are. I don't know how that could be part of the agreement.
Right.
I tend to agree with that, Your Honor. We'd have to address that separately.
Well, I don't,
Not separately.
I think it needs to be addressed. And if it's all going to be part of the agreement, it's part of the agreement. I mean, his rent's going to be contingent on certain repairs being made. And what he's talking about, it seems here,
Mhm.
you don't know about because he just brought that up. But here's what I'm going to do, gentlemen. I'm going to adjourn it out 1 week. Mr. Cater,
Yes, sir.
you are to supply a list to council and the court regarding what repairs you claim need to be made.
Yes, sir.
And you're to do that by Wednesday of next week.
Yes, sir.
What is Wednesday's date?
Wednesday is the 13th.
And so that's by September 13th, 2023. Then I'll adjourn this matter out to September 15th, right? 2023 at 1 p.m. and see if you guys can get everything wrapped up. It sounds like you got the money part wrapped up. Let's get the repair issue wrapped up.
Yes, sir.
Thank you.
Thank
Your
you.
Honor.
Blue Heron Point versus Mary Jordan.
Good morning, or good afternoon, Your Honor. Christopher Borgen, hearing on behalf of the plaintiff. Good afternoon, Your Honor. Ryan Comrie and Perry Bauer, student attorneys with the Michigan Civil Criminal Litigation Clinic, requesting permission to practice under the Michigan Court Rule 8.120 for the supervision of David Santa Croce and on behalf of Mary Jordan. Mary Jordan's present in court today.
Wait, he was.
That was so lovely. Okay, let's break that down. He gave his name. I think he gave his license number. You should give your name and license number. But I don't think he's licensed. He might. So, he's a student attorney, so he doesn't have one. That's probably why. So he gave his name. He asked for permission to practice under the supervision of which attorney and on behalf of which client. Lovely, lovely intro.
So
Lovely.
professional with that.
Yes, professional.
You did well.
He did.
Lovely.
He did that. I
He
think
did
I
very
met you
well.
before, right?
I don't believe so, sir.
Pardon?
I don't believe you've met me, Your Honor.
Haven't? Where are you from?
I'm from Michigan, Owasso,
Okay. Where'd you go to undergrad?
Harvard, sir.
Where?
Michigan of the East, Harvard.
That's funny. That is hilarious. You went to Harvard. That's why it was so like proper and everything. He's gonna start using big words. I'm just a country judge. All right. So we'll do it. Permission to practice is granted. Welcome aboard, counsel. All right. What are we doing on this case?
Your Honor, the parties would request a 2 to 3 week adjournment. There is still some issues to work out getting Mary Jordan's rental assistance application in, as well as some additional confusion on plaintiff's side. There's been a changeover in management company, and frankly, it's a little bit unclear whether we represent them. We are reaching out to the new management company and ensuring all of the steps to just resolve this case and ensure representation on the records proper. But we just need an adjournment to just secure those things.
Is there a response to that?
Yeah, we sent the correct forms to the opposing counsel on August 7th and heard back from them yesterday that they'll have those done by Monday. So an adjournment for a week or would probably be sufficient.
Well, I think
2 weeks
Mr.
would be
Morgan's
fine.
asking for 2 to 3 weeks.
That's good with us.
Okay. I see Mr. Santa Croce nodding, so you just parroted that, didn't you?
Yes, David Santa Croce is like, listen, it's 2 weeks. We need 2 weeks. It's good. He's graduating, so kudos to him. He's probably taking his bar exam and is waiting for the results. Hopefully all will be well. It's an exciting time, but it's a nervous time, right? Coming before the court, making sure you say the right thing that you do. So once he gets more familiar, he'll be real at ease with it. It'll just come off like butter. He did really good this time around, but David's in the background like 2 weeks. He's trying to help coach him.
All right. So I guess I'm concerned about, you had mentioned something about housing assistance.
The form is for the VA housing assistance. So the VA is.
Oh, it's a VA. Okay.
Background. Yes, Your Honor.
All right. Because the other housing assistance, that's whatever it is. So would the 29th work for you guys?
Yes, Your Honor.
That works for plaintiff. Thank you, Your Honor.
Okay. Of course it will work. You're a student. You don't have anything else to do. September 29th, 2023, 10 a.m.
That's cute.
All right.
Thank you.
Thank you, folks.
Thank you, Your Honor.
Excellent.
Michigan of the East, that's Maryland. BSJ Real Estate versus David Genzic.
Good morning, Your Honor. Corey McCord on behalf of plaintiffs, BSJ Real Estate and Michael Maggieri.
Is it Genzic? They're not here. Counsel, do you want to take it to fall?
I do, Your Honor.
Just raise your right hand to be sworn. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
All right, state your claim.
Corey J. McCord on behalf of the plaintiffs, Your Honor. Plaintiffs purchased this property at a foreclosure sale on June 22nd, 2023, pursuant to MCL 600.3238. They posted for an inspection on June 30th. Defendant canceled that inspection. Defendant refused to reschedule a new inspection. Pursuant to that same statute, plaintiff Maggieri posted on July 7th, 2023, a notice of intent to commence proceedings. The defendant has not appeared at either hearing. To the best of my knowledge, the defendant is not in the military, not a minor, nor suffering from any disability. I would ask this court to enter default judgment for possession, which pursuant to the statute would thereby vest title in plaintiffs and extinguish the right of redemption.
Judgment to the plaintiff, or judgment for the plaintiff, for possession, no redemption amount. Writ to issue 10 days.
Thank you, Your Honor.
Thank you.
Okay, excellent. So what we learned there is if you're not in the military, a minor and some of the other things, and you don't have certain protections or possibilities for extension, because the VA typically will intervene under certain circumstances and help with payment and give you housing assistance. Since this particular tenant doesn't necessarily, it's not noted, I don't even know if they've ever talked, but it's not noted that they are a veteran and don't have a disability. So consequently, it's highly unlikely they would get that particular assistance. So they're going to get a default judgment. This is why I say make sure that you show up for court. Don't ignore the envelope. Don't pretend like it didn't come. Someone at one time was like, all they did was, it was just on my doorstep and I had someone else read it and someone else tell me what was in it. I wouldn't touch it. I wouldn't read it. I don't know what it said. Didn't work out too good for that litigant because they're responsible for reading their mail. And the process server had done an affidavit saying that when I served them, they wouldn't take the envelope out of my hand, so I just dropped it. And that's drop service. It's personal service. You don't have to have it in your hand. If they can attest to the fact that they gave it to you and you let it fall, that's fine. You can take it and throw it in the trash. But problem is you are still bound by the laws that it is governing. You are still bound by the case. So if you don't show up, pretend like it doesn't exist, you get a default judgment. So it doesn't behoove you. It does not benefit you whatsoever to just pretend like it doesn't exist.
Court, let's call the case of Linden Park versus.
Oh, another thing. I even have individuals who are like, oh, they said they won't file it. They'll, it'll go away. They said this, they said that. That's great. People say a lot of things. If they're giving you a legal document in writing, you want a written document that says that they're going to, not file it or whatever the terms are, and you both sign as an agreement on addendum to a document, but or stipulation, or that they file and serve you with a dismissal with prejudice, meaning they can't come after you at some later date. The last thing you want to do is believe that they said this and that's what they're going to do, because if they file it in court, you are unnoticed and you have responsibilities with the court. So whether they do what they say they're going to do or not, you still have to perform. So be careful with that, get legal advice, but don't just take their word for it. If they're giving you something in writing and then they want to say something in contradiction to what's in writing, almost every agreement says the amendment or addendum to the agreement has to be in writing. So make them write it down, write it, sign it, date it. Great. Now it's something we can rely upon. Otherwise, they say a lot of things, okay? People say a lot of things and do a lot of nothing.
Harold Robertson.
Good afternoon, Your Honor. Norman Whitty appearing on behalf of the plaintiff, Linden Park.
Oh, I love his background.
And he's at an access point. All right, Mr. Robertson.
I love good branding.
Can you
Good
unmute
job.
yourself? If you hold down the space bar, you'll unmute.
Good job, Norman. Great branding.
Got it.
Okay,
Okay, state your name, sir.
Harold Robertson.
All right. And where are we on this case? How much is owing?
Your Honor, at this time, rent to retain is due in the amount of $1,349. Court costs are $158.94. Total amount to retain possession would be $1,507.94.
All right, Mr. Robertson, what do you have to say about that, sir?
That is incorrect. I sent in a certified check. It was said that a payment that was due was $26.48. That's exactly what I paid.
How much did you send in?
$2,648. A cashier.
$2,648.
Yep, and I sent it certified mail.
When did you send it?
I sent it to Linden Park Apartments, the 31 West Road. Through the portal, it said they could receive the payment.
That they didn't?
They did.
Okay. So you don't think you owe anything?
No, not this amount. I owe my rent that's coming up due, but that's a whole different issue.
Well, hold on. You're saying you owe for September?
I owe my rent for this month is due now, and I'm gonna take care of that. But when they had me come in for my hearing, I was supposed to pay $2,648. I paid it that day with a cashier's check.
Okay, so listen closely to what's happening. So let's say his hearing was in August, because we're like right September. So the problem for him is that when you make your payment in August and you're paying for August and whatever July or June, whatever the past months are, you still have to contend with September. Be careful. If your hearing date is after the first of the next month, the judge is going to require that you make that payment too before they relieve you of the case. So, be careful about that. When you're negotiating your hearing date, this little trick right here, you might want to negotiate for the 30th of August versus, contending with next month. Because what the judge wants to make sure is that everything is cured. So everything will continue to tick along if you're only making payments for what's old in the past and not contending with what is currently owed. And he now currently owes August. I mean, he currently owes September, and I doubt Judge is gonna dismiss the case because he can't. You have an outstanding balance.
Send it in.
Okay. Counsel, can you clear this up for me? I'm just not.
I think he's paying the complaint amount, and I believe that was paid after the first of the month. So what we're looking at now is just September rent that's still due. And since he never got to a zero balance, we didn't dismiss the case.
Yeah, you got to get to a zero balance.
So, Mr. Robertson?
Yes.
When are you going to pay the $1507.94? When can you get that paid?
What? I haven't even received
Robertson.
papers on that.
Well, okay. Let me put it to you this way. Mr. Robertson.
Mr. Robertson, calm down. He's getting ready to go down the judge's throat. He's like, what you talking about exactly right now? I don't have nothing on that.
If plaintiff files a complaint, let's say, let me just use different months. Plaintiff files a complaint in January saying that you haven't paid your January rent. The case doesn't get set until February and you haven't paid your February rent. The plaintiff can take a judgment for both January and February. They don't have to send you new paperwork. Okay. So in this case, it seems to me that there was the $2,648 that you say you paid. Plaintiff acknowledges that you paid that.
All right.
But it was paid after more rent became due, which is after the first of the month.
Okay.
That's why I asked you, when did you send that? Because
on the first of the month.
Okay. And then your September rent became due, and plaintiff didn't receive that until after the first of the month where more rent became due. Okay.
Another thing you be careful with, people will calculate their different debts due based upon their grace period. So if you get a grace period to the 15th, you're like, oh, my rent's due the 15th, and my credit card's due the 15th. No, it's due the date it's due. Okay. So the rent is due on the 1st. Let's say they give him a grace period, typically 3 days. So he has until the 4th or the 5th to pay because the 4th is a holiday. You get a grace period, but your due date is still the 1st. So when the court is calculating due dates and payment times, they're going to go by the due date, not the grace period. So be mindful of those contingents as well when you're, strategizing on your case.
So they could take a judgment or get a judgment for your September rent.
Okay.
So that's why I'm asking you, when are you going to get your September rent paid?
Okay. The September rent, which is actually $12.94.
Okay, but they're entitled to their court costs.
So as long as they're in court and those costs continue, you still have to continue those payments. Oh, poor Mr. Robertson.
October the 3rd, I paid the $1,500.
October?
Okay, so here's going to be our problem, Mr. Robertson.
So you're running
I get
a
what
monthly rear.
you're saying, but if you pay that $1507.94 on October 3rd, they're not going to dismiss the case because now October rent's going to be due.
Right.
You
follow me?
Yes. October's rent and September rent, I paid both of them on the 3rd.
Okay.
Okay, so
Okay.
Mr. Robertson, let me just ask you this. Do you get the one check a month? Is that the deal?
Yes,
Okay, all
Oh.
right, I got it. And so when you paid the
Wise judge.
2648, that was
Wise.
really part of the September check that you got, right?
you're correct. Yeah.
Okay, I see where we are. All right. So counsel, I don't know what you want to do on this. I mean,
Your Honor, I'd be happy to meet with Mr. Robertson and my client in the breakout room to see if we can reach a resolution.
I don't like breakout rooms, but okay, you can do it. I'm just that's fine. We'll put you into a breakout room. I'm just going to let you know that I mean, from my perspective, he paid a good chunk of change here. It seems to me that by October 3rd, really what Mr. Robertson's telling me is he's going to have both months paid.
Correct.
Right. And I think
I'll do a conditional dismissal.
and I'll just put it this way, Mr. Robertson's not saying it, but I think the reason he wanted new papers served is because he knows he's in this position. He only gets the one check a month. He's not going to be able to do anything else. And quite frankly, I'll just be honest with you, I'm not putting him out for that. I mean, he gets the one check and he's willing to pay it. So
Can I make another suggestion? If I can just inquire my client, Ashley, how do you feel about adjourning this to after the 3rd? You're muted.
and she was eating something. It's okay.
Yeah,
Now
right.
all right, go ahead.
I have a cold. No, I think
Oh.
that's fine because I was checking his account while he was speaking, but I didn't want to like jump in since he offered the breakout room. He only owes like 13 something. He owes. Hold on, I'm checking right now.
1349.
1349. So
Yeah.
yeah, that's fine. If he's good to do that by then, that's fine with me.
So if we get it adjourned past the 3rd and he makes a payment on the 3rd, we'll just dismiss the case and that'll solve all of this.
Right.
Yeah.
If he makes a payment of
Yeah.
September and then his October rent, then it can be okay. Mr. Robertson,
Yeah.
Robertson,
Yes.
will that work for you?
Yes, you just adjourn it after the 3rd, make it the 7th, 8th. I'll make the payment.
Okay. You were trying to get angry with me, weren't you?
No.
Yes, you were. No, it's okay. It's okay.
No, I wouldn't get
No,
angry with you because you know too many of my relatives. I know you,
What'd you
my
say?
uncle, Jimmy Moore. So I know you.
Oh, you know me? Okay.
Yeah, I know Jimmy
I
Moore.
was not aware of that, but
Oh,
you
so
seem like
he's
you were
my
trying to get
uncle.
angry with me. I'm like, whoa.
And
So what
Fred
day do we
McDonald,
have?
was a friend of mine. So you know, I'm gonna take care of the business. I was sick. I was in the
Mr.
hospital.
McDonald.
Okay.
Mr. McDonald was the person that gave me my first start in the practice of law.
Right. I used to see you in
And
the office.
was my partner. So
Yeah, I used to see you in the office.
yes, sir.
I was sick, and I had some heart problems. So that was the reason why the rent was all tangled up.
Okay.
That's all
I'm
I'm
gonna
back
get you caught up. So I'm gonna give you a date of October.
We can do
Six.
October 6th at 11 a.m.
So I'm gonna turn this out to October 6th, 2023 at 11 a.m.
Okay.
Okay, you get that paid and it will likely then be dismissed. Okay, Mr. Robertson?
Okay, I will.
All right. Thank you, sir.
Thank you, sir.
All right, so kudos to this particular Linden Park, Miss Ashley. I don't know if she's a project manager or owner or whatever, but kudos to her and Attorney Norman for working with Harold Robertson because sometimes that's the situation. You get paid once a month. You want to get paid? You want me to pay you September? I'm gonna pay you September and October. That was cute. He's like, no, October 3rd.
Case of Linden Park
Wait,
versus
Yeah,
is it Kimberly? Is it Puritan?
Puritan, you're right, Your Honor.
Puritan.
That's correct.
Okay. I had as of last week 5,390. Can't read Judge Barr's number.
I hate covering up the judge.
Maybe 92. And 90.
He's the only one that doesn't move. His
Yes.
moves.
I think we have a late charge that might have hit. The
Okay,
balance
how much
showing
is-
us at today's date is 5302, court costs of 159.92, total to retain 5461.92.
6192. All right, Ms. Puritan,
I'm gonna
how
make a
you gonna
payment.
get that paid?
I'm gonna make a payment next week and then I can have the balance paid by the end of the month.
So how much are you gonna pay next week?
I'm not sure between 1,500 and 2,000.
And then you're gonna have the balance paid by what date?
2 weeks following that.
Okay, so the 1,500 to 2,000 will be paid by what date?
Just say next Wednesday.
The 13th?
Yes.
Okay, that'll be paid by the 13th, and then you're saying that you'll have the entire balance by the 27th.
Yes.
All right. So here's what I'm going to suggest to the parties. Judgment for possession would enter in the total amount that plaintiff claims of the $5,461.92. That, ma'am, when you say between 1,500 to 2,000, what's the realistic figure you can pay, you think?
1,500 is realistic because I'm waiting to hear back from a family member to assist with the balance.
I got you.
Yeah.
That's fine.
Mhm.
So defendant to pay $1,500 by the 13th. If not paid, a writ would issue on the 18th. If paid, defendant to pay balance by, you said that next Wednesday, by the September 27th, or writ to issue. How does that sound to the parties?
Let me just inquire of
Okay.
my client because I don't have
No,
negotiating.
it's okay.
authority. It's fine by
Ashley,
me if it's
looking
fine
for
by
you
you.
again.
Did we lose her?
No, I'm here.
No,
There you
she's
are.
here.
She moved on my screen.
Oh, sorry. Yeah. By the 27th.
Yeah.
That's fine. That way it won't fall into the next month. So yeah, that's
Next
fine.
month. So, but she's gonna make a good faith payment of $1,500 on the 13th, Wednesday of next week. If she doesn't pay that, then a writ can issue on the 18th of this month.
Okay. And then if she
Okay,
does
but if she
pay,
makes
it'll be
that
18 on the
payment,
27th.
right, and if she makes that $1,500 payment, then she gets to the 27th to clear the balance.
Okay, that's perfect.
Okay,
Thank you.
thank you.
You
You
wanna
got
draw me
that,
to
Ms. Puritan?
Oh, sorry.
Yes, I do.
All right. So this will be a judgment by consent with those terms. Ms. Puritan, I
Okay.
do have to advise you pursuant to Michigan Court Rule, you have 3 business days to think about this judgment. If you believe that there's some legal reason, some right you didn't assert, or some confusion on your part, you'd have those 3 business days to file a motion with this court. You understand that?
Yes, I do.
All right. Doesn't mean I'd grant it, but you could file a motion to set it aside. Okay?
Okay. Thank you.
All right, Ms. Puritan, you have a wonderful weekend.
You too, Your Honor.
But I don't think this is the same day as the last litigant that had the dog. But you can tell the judge is still like, listen, you get 3 days, but to make a motion, but it doesn't mean it gets granted. So make sure you understand what you're agreeing to,
Your Honor, shall I
Take care.
submit that judgment by email then?
what the terms are.
Shall I submit that judgment by email then?
Yes, you can email it to our clerk's office. You can get it to us and I'll sign off.
Thank you.
Thank you. Linden Park Apartments versus James Brewer.
Good afternoon, Your Honor. Norman Woody appearing on behalf of the plaintiff.
James Brewer.
He has not checked in. Would you like to take a default? If you do, please raise your right hand.
We would request a default at this time.
Okay. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All
Your Honor,
right,
this
you
is
may
a-
proceed.
I'm sorry, Your Honor, Norman Woody on behalf of the plaintiff. Your Honor, this is a eviction case.
What
Oh, you
happened?
muted yourself, counsel. You're saying brilliant words, but I can't hear
Brilliant.
I actually get much more articulate and eloquent when I mute.
them. Okay.
Rent to retain is currently owed the amount of $2,529.60. Court costs are $159.92. Total rent to retain is $2,689.52. To the best of my knowledge, the defendant's neither a minor, an incompetent, or in the military service, and the landlord has kept the premises fit for their use as a residential dwelling.
Judgment to the plaintiff, that is by default for possession. Redemption amount is in the amount requested with the writ issued 10 days.
Thank you.
All right, thank you.
Have a great weekend.
Okay, so all the attorneys and representatives, did you hear that the part when he got to the end, he also said that the landlord has kept the premises habitable. The dwelling is habitable. That's one of the major issues for holding rent. So he's dispelling that and saying, no, Your Honor, that's not an issue. This particular tenant is not paying. They're not showing up. We're good for a default judgment. There are no other issues that would prevent him from paying or assist him in paying, such as the rental assistance for VA and so forth. So be careful. I don't know why you don't show up. You should be showing up, but maybe he's already moved out. Hopefully he's gotten his new place and is willing to move on and not have to fight this. But he still gets a default judgment against him, which if you can avoid judgment against you, please try to do so. And then, like I said, for the attorneys and the landlords, your representation would be that the premises is habitable. It's very important that you're keeping it up to code, and suitable for living.
I think that's it. Yep, you do the same.
Thanks.
Huntington National Bank versus the estate of Dwayne, is it Bauer? Anybody here?
Yes, Your Honor. Tobias Lipsky appearing on behalf of Huntington.
All right.
Speak up.
No one is here for the estate. All right. This is a termination. All right. Sir, would you like to take a default in this case?
Yes, Your Honor.
Raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
All right, you may proceed.
Tobias Lipsky, P 62859 on behalf of plaintiff Huntington. This is a termination of tenancy proceeding following a foreclosure which occurred on January 19th, 2023. Redemption expired July 20th, 2023. Plaintiff requests a judgment of possession with the writ to issue on September 18th.
Judgment to the plaintiff. That is by default for possession.
Okay, so we talked a little bit about the foreclosure and then possession after foreclosure process. If you are a tenant and your landlord has failed to make the payments on the house and you're having a foreclosure, you do have squatter rights. So obviously, in most areas, so look that up, make sure that you in your area would have squatter rights. Try and do that research and speak with a advocate on that regard. Don't ignore the paperwork, okay? Because you may be, you may have rights to stay a little longer or to get cash or keys or something to help you move on. Especially if you can prove that you've been making your rental payments throughout the time that the landlord failed to make the mortgage payments. In this representation, there is nothing defining the tenant. So the tenant could in fact be the homeowner that has been foreclosed upon, or they could be a tenant that was, paying rent to that a homeowner is a landlord. So don't know the particulars of this case, but just want to make sure that you're aware that if you were a tenant and you were making payments, you would have squatter rights and there would be some help and assistance for getting you relocated if in fact those particular laws apply to where you're located. So make sure that you look into that and don't ignore your notices.
Redemption amount is in the.
All these
there is no
default
redemption amount.
judgments.
Writ to issue in 10 days. Thank you. All right, you're all set. Thank you.
Defaults all day. Might have been able to fight it. I don't know.
Vicky Markenhorn versus Ashley Campbell.
Ashley Campbell here as a defendant.
Okay. Miss Markenhorn, can you unmute yourself?
He's in the courthouse.
If you hold down the space bar, you'll unmute.
Space bar.
Oh, there we go.
Good morning, good afternoon, Your Honor. How are you today?
I'm okay. All right.
Could I address the court right now, please?
Yes, go ahead.
I'd like to ask for a possession judgment today and let them keep all their rent money and just give me my keys. This is my great niece and I am her aunt. I own the home and I live in the bottom and she lives in the top. And it's tearing our family apart. She has gave numerous texts, and you have copies of them in your file you should have, where she said she was willing to pay the rent and never mentioned anything of any problem.
Tile, a problem with the house.
Let me address the judge. And I'm sorry, that's my husband.
Vicky,
And at this point, I would just like them to go. They did speak to Judge Carr on Friday, and we acknowledged that they could move. And they said they would take a couple days, they would move. They haven't moved, and that's what I want for this outcome. Because I'm not well, Your Honor, and it is tearing me apart. I can't sleep, I can't eat, I can't work. I work 60 hours a week and I'm 70 years old and I'm trying to survive, but I don't know what to do. I just.
All right, hold on a moment. Okay. Ashley, what do you have to say?
So I have an inspection set up for next week, since I was denied it before. However, if I'm given 30 days to move out, I'm willing to drop everything. However, I do need 30 days because my girlfriend and our child are here and she has to inform the court of where she's moving to. So we have to have a couple days to inform the court of where we're moving for child support and custody.
My address.
All right, so let me just ask this.
Okay, the inspection, well, maybe the judge will get into it. Can license be Section 8? I believe that's what she's talking about. So she was denied before. I don't know, but maybe that's what she's talking about. Otherwise, there's two ways of inspecting. One is I'm calling the code enforcement on you because it's inhabitable, and I'm having the inspector come out and determine what you need to fix. Part two, I'm getting some type of rental assistance, and the inspector's coming out to ensure that the place is livable so that they will help me with the rent. So I'm not sure which one she's talking about.
And so that I understand what you're telling me, Ashley. Ashley, you say that you can be out by October 6th.
Yes, Your Honor.
All right. So Ms. Markenhorn, would
Let
that
her
work
go.
for you?
Just let her go.
That's all we want.
Okay,
That's
so
it.
here's what I'm gonna do, folks.
You can give me my keys.
Hold on.
Okay. Okay, I'm sorry.
I'm converting this to a termination case. I'm gonna issue a judgment for possession.
Oh,
That's, the court will issue that finding no tribal issue in the case, so I'm doing that after a hearing. And that the writ date would be October 6th, 2023. Okay, so I'll start with the defendant, Ms. Campbell. Do you have any questions regarding what I just did?
No, sir.
All right. And to the plaintiff, Ms. Markenhorn, do you have any questions about what I just did?
If they don't move out, what happens then?
Then you have to file what's called an order of eviction.
Okay,
When can we do that?
Okay, so you're at the courthouse right now, correct?
yes,
So what I suggest you do is go out to the counter and fill out a judgment form that has to be so that it can get down to me for my signature.
okay.
Okay,
And
and
what is-
then if they don't move by that date, then what happens is you'd have to come back to the courthouse and file a order of eviction, pay the $15, I think it is, and then ultimately that would be signed off by me if they haven't vacated the premises.
Okay, that's perfect.
That's perfect.
and give it to the
All right.
sheriff.
Any questions from anybody?
No, sir.
No?
Nope.
All right, great. Thank you, guys.
Thank you
Thank you,
so much,
Judge.
Your Honor.
Till 1. All right, court stands in recess.
Oh, wow. So that was a sad one. I mean, because she started crying, of course, and it just seems like to be tearing her apart. She has a lot going on financially and just wants someone that's going to be there to pay rent. And that's what we forget. I know that this is a family member, so we obviously expect the family member to know, but also landlords in general. You know, there's some renters, not all renters, but there are some renters who just feel like, oh, they're the big landlord, they have all the money, and they can just wait and I'll pay it when I pay it, they'll be all right. That's not always the case. Everybody is not in landlord business and booming so much that they don't need your rent. It's one, a part of the responsibility of you as a tenant, and also two, it can go towards things of their survival. And in this particular instance, she's finding that not getting her rent and having to pay those hours are very taxing upon her. So let's just be mindful of that and see what we can do to work with our landlords, but ensure that we're not stiffing them just because we think they make so much money. All right, let's see what Judge has for us. Sure. Reese.
And I'm live.
The 14A District Court is now back in session. All those having business before the court draw near. The Honorable Judge J. Cedric Simpson presiding.
And court does call the case of Scio Farms versus Elizabeth McClellan.
Good afternoon, Your Honor. Rachel Dornbush, Palance Law, on behalf of the plaintiff.
Hello?
Hello, Ms. McClellan?
Yes,
How are you?
I'm good. How are you?
I'm okay. Okay, where are we on this case?
Your Honor may recall, we were in court last week and Ms. McClellan had indicated her intent to borrow some funds from a friend and to have the account paid in full before today's hearing. And I believe she intended to have it paid on the 5th. I have a ledger here dated 9/6 showing that that payment did not occur. And the court may recall that I had requested, and I believe Your Honor had indicated they would grant a judgment with the 10 days running from last Friday based on that assertion. So we would request entry of that judgment today.
She sure did. And he sure
Ms.
did.
McClellan, what happened?
I I forgot it was the holiday, so I couldn't get a hold of my friends.
Huh?
And I made $1,000 payment today.
Are you current?
All right, but that's still gonna leave about 1,700.
Yes. And
So, Mr. Ornbush, you have that 1,000 or?
I don't, Your Honor, but I'm happy. I was actually just trying to call my client to see if they've gotten any payments. And then Your Honor took the bench. So I'm happy to check with them to verify if they have that 1,000. And if so, then I would request the judgment for the remaining balance with the 9/11 writ date.
I'm gonna find no tribal issue in this case, and after hearing, I'm gonna grant judgment for possession to the plaintiff. Total amount.
Without that
Here's the 20
$1,000
Yes.
payment, Your Honor, is 2768.23. Breakdown is 2594.23 for rent to retain, cost being 174, total 2768.23.
Judgment to the plaintiff, in that amount with a writ to issue. It's the 11th. So, and I know I said that. So, Ms. McClellan,
yes,
you got till Monday to get this all cleared up. You told me that you were gonna pay it.
yes, and I had planned to, but I forgot the holiday.
Okay, but Ms. McClellan, here's my problem. Right, before that, I told you to get to the Ann Arbor Housing Commission because they could have gotten this
Yes.
taken care of. You told me you weren't gonna do that. You were gonna go.
So that was the one that I was trying to figure out, Ann Arbor Housing Commission. So for those who are in that area, another rental assistance is Ann Arbor. That's what he's, Ann Arbor Housing Commission. So look into
Go
that.
to your friend.
Right,
And I gave you time to do that.
yes,
And then that didn't happen. And so now you're just up against the wall on this one. So you got till Monday to get it done.
okay,
Writ to issue the 11th.
That's a lot
Thank you,
too.
Your Honor.
And he did agree. He says fine, because he had faith in her that she would get
Thank
it
you.
done by the 5th, as she had represented. That's
Calls case, Scio
unfortunate.
Farms versus Antoine Bailey.
Hopefully she can get it done.
Antoine Bailey? Nope, you just remuted yourself.
Okay, it's on Zoom.
All right, I'm here.
Okay. All right,
Yes,
what's the
Your
claim
Honor.
in this case?
Now, Your Honor, total due $2,996.54. At the court date before Judge Bauer, Mr. Bailey had indicated he was going to pay $500. I don't see it on the ledger, so I would just defer to Mr. Bailey as to whether or not he's dropped off that payment since then.
Mr. Bailey?
I have not dropped the payment off. I do have the money order. I've been in the hospital with my child in Ohio since Friday. When I said I was going to make the payment, I do have that, and I need until the 18th, and I can have everything paid in full.
By the 18th?
Yes.
All right, here's what I'm gonna do then. It's 2996.54.
That is correct.
All right, what I'm gonna do, Mr. Bailey, is I'm going to find out that there isn't a tribal issue for me. So after hearing in this matter, I'm gonna issue a judgment for possession in the full amount of 2996.54. And you're gonna have it paid by the 18th, right?
Yes, by the 18th.
All right, so Rich.
Okay, so for some of our landlords, we only want our money in our hand, cash or the check in our hand. And you want them to either drop it off or you want to go pick it up from them, and you don't necessarily want them to mail it. And I understand that you don't want them to mail it because things get lost in the mail. But you may want to invest in a system where they can pay online. Now, I'm not talking about Zelle. I'm talking about a real online system so that you can have full records. Zelle does a good job of having records as well, but it would be best for you that you put it on a online tenant landlord system, because then the tenant can go back and review the ledger. And then if you need to send it to the attorney can get access and review the ledger. And if they have to go to court, you have a simple process, and you don't have to go back and forth making screenshots of sale payments and so forth. So it's a much more efficient system to have it in a landlord tenant type software. But I do encourage you to work on, expanding to the times that you allow payment online. Now, there may be the case since they are in court that this requirement was for him to go drop it off. But him being out of town or being in the hospital with his child becomes now an extension of time. They have to wait for the payment. When you have things automated or a system online, you don't have to wait for the payment and you can report it immediately. So, that's a suggestion.
It's issue the 18th as what it would be. So I'm just giving them a judgment, get it paid off, and you'll be all set.
Thank you.
All right, thank you. Hope your little one's doing well, sir.
All right.
Take care. Court calls the case, Scio Farms versus Danielle Barrera, excuse me, and Amberly Chronic. Neither tenant has checked in. Would you like to take a default?
Yeah,
Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do. For the record, Rachel Dornbush, Palace Law, on behalf of the plaintiff. Your Honor, there's rent to retain of $5,335.73, cost of $200 for a total balance of $5,535.73, and we'd request a default possession only judgment with writ to issue in 10 days.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ to issue in 10 days. Scio Farms versus Maybell Burr. Maybell Burr, no response. You may proceed.
Thank you, Your Honor. There's rent to retain of $3,201.22, cost of $174 for a total of $3,375.22, and we'd ask for a default possession only judgment with writ to issue in 10 days.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ to issue 10 days. Scio Farms versus Amy Fields. Amy Fields, not here. You may proceed.
Thank you, Your Honor. There is rent to retain of $4,542.74, cost of $174 for a total due of $4,700.
All right, Silo Farms in Michigan is expensive. They got LA pricing.
$16.74. We'd ask for a default possession only judgment with writ to issue in 10 days.
Judgment to the plaintiff by default.
Everything's 5,000, 4,000.
Writ to issue in 10 days. Scio Farms versus Jessica Jones and Shaman Jones.
Shaman's here.
Okay, Mr.
All right,
Jones.
somebody.
Okay,
Yes.
what is plaintiff's claim in this case?
Your Honor, total due with court cost $2,106.12. When we were in court before Judge Bauer, Mr. Jones had indicated that he would pay $500 that day, another $800 on the 17th, and was requesting to have until the 30th to pay the full balance. I show a payment of $9/6 of $200 rather than the $500 requested, or excuse me, $500 promised. I don't have authority as of now to extend the written date out to the 30th, but I would defer to Mr. Jones with respect to the difference in payment.
Yes, I actually made another, dropped off a money order yesterday at 500.
Okay.
So I should be down 700 right now. Should be minus 700. So we should be at 1,500. And my wife is going to pay another 500 today. That should take us to 1,000. And we'll pay the rest by the 30th. We'll have the whole 1,000 by the 30th.
Your Honor, if we could pass on this matter, I'll verify with my client receipt of the 500 dropped off yesterday. I presume they don't
Okay.
have the 500 from today yet. And I will inquire as to whether or not they're willing to give them to the 30th. I doubt they'll go to the 30th since it's a Saturday. They may go to the 29th, but that may be a stretch. So I'll verify with them if we could pass on it.
Okay, Mr. Jones, hold on.
The 29th is fine with me. The 29th is fine. I just said the 30th because I get paid on the 15th and then the 30th. So that's the only reason I said the 30th. So it could be the 29th.
Gotcha.
So.
Okay, all right. You just hold on the line and let well, as soon as we get through some of these, she can check with them and see if we can work this out. Okay.
Yes, sir.
All right. Scio Farms versus William Kirk, Shantaris Lawrence, and Jewel Jackson. Any of these folks present? None of them are present. You may proceed.
Thank you, Your Honor. There's rent to retain of $4,295.
All right, so we're getting into some repetitive default judgments. Let's just go ahead and let those run. That was a very interesting day in Judge Simpson's court. I hope you enjoyed and learned a few things. I know that we have some great takeaways, whether it is for landlords to make sure that the place is habitable so that there is no claim of inhabitability, as well as you can use a software so you can get paid quicker and have a record of those payments. It is an investment, but if you have more than a couple of properties, it's a great investment to make because it keeps things in order and simplified so that if you should have to go to eviction court, your attorney can have access and have records at hand instantaneously and not have to go back and forth with screenshots and emails, right? So I do suggest you look into that. Obviously, if you are living in a property that your landlord has lost due to non-payment, please look into if you have any squatter rights or what can benefit you as in moving on and relocating. Sometimes just having that conversation with the new owner and saying, you know, I've been making all these payments. They have my deposit. You know, they just taken off. You foreclosed on them, but I've been making my payments to them. You know, now I'm in a rock and a hard place. You might get some cash for keys. You just might get relocation funds, especially when you're dealing with a big bank. They typically are available with those funds. I mean, not to say that banks are rich, but just that they do account for the fact that they may need to put a few dollars aside for cash keys in order to gain possession and to avoid court. Then if you can make those negotiations prior to getting to court, you save them court costs. They can use that fund to put into your pocket so that you can relocate. So, you know, get smart and strategize about how you're going to exit. Doesn't mean that you don't have to exit, because if you're somewhere unlawfully, you will need to exit, but you do have some measures or some, you know, some chips you can play with and maybe get a few things in return so that you can relocate with a simpler or at least some kind of assistance. We got Ann Harbor, so Ann Harbor housing. So if you are in Michigan, there's a Ann Harbor housing that is aside for rental assistance. You have HAWK, Section 8, of course. And you can look into all those various things to determine, you know, if that is suitable for you or your friends. So make sure you like, share, and subscribe. We've learned a lot. We had a great time. Judge Simpson was jovial. He had some laughs today, so we had some enjoyment talking up with him. You know, one of the litigants, you know, was getting a little snippy, he doesn't think he was. And sometimes I do that. I'm like, you know, talking and the person is like, what? Animated. I'm like, I'm just talking. Like, no, you're animated. Like, chill. So we sometimes don't realize, but I thought he was being snippy too. So be careful when you're in court to keep those kind of things in check, because you want to be mindful of how you'll be perceived. Sometimes the intention is one thing, but if you are perceived a different way, then, you know, you're going to have to deal with that and they're not going to believe you. So be mindful when you present in court. That was fun. It was fun and cute. So share so our family and friends can learn in case they're in this situation. And thank you for being here and watching us. So like the video and subscribe so you can get the next one. All right. All right. Armstrong, your real estate agent and advocate. Have a good one.